The Indian Supreme Court delivered a very important judgment concerning the Negotiable Instruments Act, the dishonour of checks, and Section 138 of the Negotiable Instruments Act in the year 2021. It was in March 2021 that the Supreme Court again considered this issue as to what is the kind of proof required to prove the guilt of an accused under Section 138 of the Negotiable Instruments Act. Whether you need to prove that guilt beyond reasonable doubt, as you do for other criminal offences, as it is mentioned in the CRPC, or you just need to discharge the primary burden, that is, you need to prove the guilt by preponderance of probabilities and leave the rest to the accused, that is, the onus then shifts to the accused. So what actually happened in this case, I will tell you in this video. This is very important for all those people who have their check bounce matters pending in the district courts, in the higher courts, and for all those people, all those students, all those who wish to gain some knowledge about this aspect. Let's just get started with our video. So all of us who are concerned with the check bounce cases or Section 138 cases sometimes think that this is majorly a case having commercial transactions between two parties, but we all know that in the year 2000, that is about 22 years ago, this was made a criminal offense. So this is basically nothing more or less than a regulatory offense. So because a lot of cases of check bounce are coming up, they were coming up at that time too, so it was thought that there is a need to criminalize it. We must include a criminal penalty in this section so as to deter people from doing such activities. Before I continue with the video, I know you people are watching it because you're really interested in the laws, you are really interested in recent changes that are happening around, and some of you are those people who have not even joined law school till now, and you are someone who wishes to join law school, wishes to become an advocate in the future, but you do not have any person to guide you. So I have come to you with an option of Unacademy courses. If you're a subscriber of Vlawgish, you will even get a flat 10% discount on purchase of any of their courses. Even if you don't want to purchase any kind of courses from Unacademy, you can still go there, log in, use the code Vlawgish and try to give their free test series, their free quizzes. You can do literally a lot without paying a penny. But in case you are interested in pursuing law, and in case you're someone who has already done your graduation and you want to go for the Delhi University's law program, then there is this new batch about which I've just got the notification, which is starting on the 3rd of January. You still have time to join this batch. It is called the DU Dream Batch. It will really give wings to your dream of studying law from the Delhi University, from the Campus Law Center or other affiliated colleges. It's a 3-month course for DU LLB entrance. In those 3 months, you will get to know literally everything about the DU LLB entrance. They will give you mock tests, they will give you notes, they will give you lectures, they will assess your preparation, and they will prepare you fully for this exam that you'll have to get, that is the DU LLB exam. It's in both Hindi and English. I have already told you that it's starting on 3rd of January, and you must not forget to use the code Vlawgish by going to the link given in the description box below if you're thinking of even purchasing this batch. The case that I am talking about today, that is a judgment of the Supreme Court in the year 2021, involved two parties. Let's say that those two parties were A and B. A went to B. Both were business persons. A went to B and said that I want to purchase this certain fabric from you. It was certain kind of non-woven fabric. So she says, I want to purchase this fabric from you. B says, okay, you're free to do so. Okay, I'm ready to get into this transaction with you. This will be the amount that you have to pay, and I will be sending the goods to you. Both of them agreed. B sent the goods to A. Earlier, A had agreed to pay the entire amount in advance, but later on she conveyed that I'll not be able to pay in advance. I'll be paying through check later when you deliver these goods to me. So the goods were delivered by public carrier trucks to A. A was happy. She was like, I have received my goods and now I'm going to pay the amount. Nobody knew the intention that was there in A's mind. Nobody knew what was going on in her mind at that time. So she gave 2 checks of around 5 lakh rupees each to B in discharge of her liability that arose because she purchased certain goods from B. तो उन्होंने चेक दिया, but then that check was returned by the bank. That check was returned dishonored by the bank. That is, the check was bounced. with the reason that the funds in the accounts of A are insufficient. Therefore, the bank cannot honor these checks. Therefore, as per the mandate of section 138, B sent legal notices to A for both these checks. Not one but two legal notices were sent, and no reply was received within the statutory period. No reply at all. Therefore, section 138 cases were filed by B against A. Now, the trial court, the lower court, the district court acquitted A, giving the reason that B has not proved the case against A beyond reasonable doubt. They said, you should have shown, even if you have shown that you had delivered certain goods to A and A had then given you some checks, but you should also have shown that this check or these two checks were sent to you in discharge of that debt. कि A ने आपको जो वो चेक दिए हैं दो, वो इसीलिए दिए हैं ताकि वो अपने वो पैसे जो हैं इंटरवोवन फैब्रिक जो उन्होंने ख़रीदा है, नॉन वोवन फैब्रिक जो उन्होंने ख़रीदा है, उनके पैसों की लायबिलिटी को डिस्चार्ज कर सकें. कोर्ट ने बोला आप उस लायबिलिटी को नहीं पूरा कर पाए, आप नहीं दिखा पाए, आप बियॉन्ड रीजनेबल डाउट अपना केस नहीं प्रूव कर पाए, इसलिए हम एक्विट कर रहे हैं. बट हाई कोर्ट ने इस डिसीजन को रिवर्स कर दिया. उन्हें बोला नहीं, कन्विक्शन तो होगा. सुप्रीम कोर्ट ने भी यही किया एंड में कि हाँ, हाई कोर्ट राइट है और जो ट्रायल कोर्ट था वो रॉन्ग था. अब ये क्यों हुआ, यहाँ से प्रिंसिपल क्या निकल के आया? वाई दिस केस इज वेरी इंपॉर्टेंट फॉर दोज पीपल हु आर इन्वॉल्व्ड इन चेक बाउंस लिटिगेशन. आई विल टेल यू राइट नाउ. Supreme Court once again very nicely clarified that if you think that the standard of proving these check bounce cases will be same as the standard required for other criminal offenses, then you're wrong. This is not a murder case. This is not a murder trial where you need to prove your case beyond reasonable doubt. No. They said, go and nicely read section 138 and 139 of the Negotiable Instruments Act once and then come back to us. Now, what do these sections say? These sections make it very clear that the initial burden to prove the case is on the person who is alleging that. That is, if B is saying कि इसने इसका चेक बाउंस हुआ, इसने मुझे इस लायबिलिटी के डिस्चार्ज में ये दिया था, तो आपको इनिशियली प्रूव करना है कि आपका कोई कमर्शियल ट्रांजैक्शन था. उसने प्रूव कर दिया कि वो मुझसे नॉन वोवन फैब्रिक खरीदने के लिए आई थी और मैंने उस फैब्रिक को डिलीवर भी करवाया था. उतना उसने प्रूव कर दिया. दूसरी चीज़ जो आपको प्रूव करनी थी फॉर डिस्चार्जिंग योर इनिशियल बर्डन वॉज दैट यू नीडेड टू शो दैट सर्टेन चेक्स वर गिवन टू यू. दैट ऑल्सो वॉज शोन बाय बी. Now, the Supreme Court said there is no need to prove anything else. Why? Because as per section 139, the onus to prove anything else now shifted to the accused. Section 139 is a section which gives a reverse onus to the accused person. Reverse onus कैसे? अब अगर इतना प्रूव हो गया है कि एक ट्रांजैक्शन हुआ था और चेक भी दिए गए थे, तो आपको ये प्रूव करना है, अक्यूज्ड को ये प्रूव करना है कि वो जो आपने चेक्स दिए थे वो अपनी लायबिलिटी को डिस्चार्ज करने के लिए नहीं दिए थे, मे भी किसी और रीज़न से दिए हो. शायद आपने वहाँ पर ऐसे ही रखवाए, जैसे कि मोस्टली लोग हम केस फाइल्स पढ़ते हैं या हम केसेस देखते हैं या जब हमारे पास हम और जजमेंट्स रीड करें तो हमें पता लगता है कि व्हाट डू मोस्ट पीपल से. दे से दैट आई हैड गिवन दिस चेक एज सिक्योरिटी. ये तो मैंने कभी डेट को डिस्चार्ज करने के लिए दिया ही नहीं था, एंड दिस इज बीइंग मिसयूज्ड अगेंस्ट मी. Right, this is the defense taken by most of the people, and most of the times this is the actual reason as well. So the Supreme Court said, now the reverse onus is on the accused. Only the accused needs to show that he had not given those checks in discharge of the liability that he had. Okay, and if the accused is not showing that, then it's his problem. तो यहाँ पर दो तरह के ओनस की बात की गई. पहला जो प्राइमरी बर्डन प्रोसिक्यूशन को डिस्चार्ज करना है, एंड द सेकेंडरी बर्डन दैट इज नेगेटिव रिवर्स ओनस वाला जो सेक्शन 139 से आता है, वो जो अक्यूज्ड को डिस्चार्ज करना है. तो कोर्ट ने बोला कि अक्यूज ने तो कोई एविडेंस लीड किया ही नहीं इसके लिए. अब जब एविडेंस नहीं लीड किया, सो व्हाट कैन वी डू? नथिंग. वी विल हैव टू फेवर द स्टोरी ऑफ द प्रोसिक्यूशन. अगर अक्यूज को लगता था कि उन्होंने ऐसा कुछ नहीं किया है या फिर उन्होंने वो चेक उस लायबिलिटी के डिस्चार्ज में नहीं दिया था, किसी और रीज़न से दिया था, तो उन्हें बताना चाहिए था, उसके लिए एविडेंस लेके आना चाहिए था, एविडेंस एड्यूस करना चाहिए था, कोर्ट के सामने लाना चाहिए था, अपनी स्टेटमेंट्स में बोलना चाहिए था, अपने लिए विटनेसेस लाने चाहिए थे, अपने फाइनल आर्ग्यूमेंट्स में भी स्टेट करना चाहिए था. But the accused failed to do so. Hence, Supreme Court said High Court was right, the trial court was wrong, and therefore we are upholding the conviction. Now, what you need to remember from here is, if you need to prove a case of check bounce, that is to be proved by preponderance of probabilities. You don't need to prove it beyond reasonable doubt. That is not the standard here. The standard is simpler, it's lower. Always remember this phrase, preponderance of probabilities, whenever you're trying to prove the check bounce cases. और आप में से जो भी लोग, जिनके भी केसेस, जिनकी भी लिटिगेशन पेंडिंग है, वो हमेशा याद रखें, अगर आप अक्यूज हैं किसी चेक बाउंस मैटर में, तो आप याद रखें कि आपको ये ज़रूर प्रूव करना होगा कि आपने जो वो चेक्स वहाँ दे रखे हैं वो आपने अपने किसी डेट, यानी कि अपने किसी उधार, अपने किसी लायबिलिटी को डिस्चार्ज करने के लिए नहीं दिए थे. अगर आप ये प्रूव नहीं करोगे तो जजमेंट आपके अगेंस्ट आएगी. इट इज़ योर लॉस, नोबडी एल्सेस लॉस. And if you're trying to prove your case of check bounce, that is if you're at the other side, अगर आप prosecute करना चाह रहे हो किसी को, तो आप बिल्कुल याद रखो कि आपको अपना प्राइमरी बर्डन तो डिस्चार्ज करना ही करना है. Then only the onus will shift. ओनस यूं ही नहीं शिफ्ट हो जाएगा. जब आप प्राइमरी बर्डन को डिस्चार्ज करोगे तब ओनस शिफ्ट होगा अक्यूज्ड पर. As per the principles laid down under this judgment and also under section 138, 139, other sections of the Negotiable Instruments Act. Now you've heard me talking a lot about this case, but do you know why this was held? What's the logic? The logic rests on the NI Act. It says that if you are the holder of a check, if you have certain check issued by certain other person in your name, it will be presumed automatically, it shall be presumed that the check was issued in discharge of some liability or some debt. Now, there is a strong presumption of consideration here. That is, that was given to you, the check has been given to you as consideration for something that you have done for the other party. Always remember this. Because of this presumption, the onus goes to the accused. जो अपने onus को पूरी तरह से fulfill कर देगा, that will be the winning party in the case. And the other party will definitely be considered at fault. So do you know from where I got to know about this wonderful judgment? How am I updated with all the recent developments that are happening around the courts? And how do I know each and every nice judgment, each and every judgment that was delivered by the courts this year in 2021 before this year ends? That is because the verdict today made it possible. They sent a copy of their journal to me, their hardbound journal, due to which I was able to read a lot many cases. And I came across this case on check bounce on section 138, so I thought I must share it with you people. If you also want to be updated, if you're a law student, if you are interested in getting to know about the laws, then you can also contact the number that is being flashed on your screen, and you can book your copies for the verdict today in advance. If you'll see the journal, खोलते ही आप पहले तो इम्प्रेस होने वाले हो इनके टाइटल, इनके इंडेक्स, इनके पेजिंग के स्टाइल से. इंडेक्स इज़ वेरी इंपॉर्टेंट फॉर एवरी जर्नल बिकॉज जर्नल्स आर जनरली ह्यूज एंड यू नीड टू सी द इंडेक्स in order to locate the case that you want to see. Now I wanted to read something on check bounce, dishonour of check. So I had to do nothing, but I just had to go to their subject index, to their topical index to get to know कि कहाँ पे मुझे डिसऑनर वाला केस मिल जाएगा. फिर उसके बाद अगर आप वहाँ से केस को लोकेट कर लो, देन गो बैक टू देयर केस इंडेक्स, वहाँ से आप इजीली केस को पहचान लोगे. So if you're a practicing advocate, if you are a student, if you are preparing for judiciary, then this is very important for you. This will prove to be very helpful for you in the long run if you are preparing for anything, or if you just want to be updated about the laws, about the changes in the laws, about new judgments, etc.